Thank you. Good morning. Mr. Hathaway. Good morning, Mr. Tusoni.
Can I have a pen? No, I can. Okay.
All right. We are here. The one motion that I wanted to handle is the motion for protective order. I was going to enter the order, but I was reviewing the most recent filing related to Ms. Gardner's case, and I was reviewing that motion. I had a couple questions. First, in that motion, it raises both the spousal privilege and the attorney-client privilege, which I know was raised in the motion that was previously filed by Mr. Dreiser, pre-indictment, pre-arrest.
Filed by Mr. Cox.
I'm sorry, Mr. Cox.
Yes,
and so I had a couple of questions before I entered the order. When we last left each other, I thought that there was an agreement for content blind review on the 8 devices listed in the motion, and I wanted to make sure that that was still the agreement. It seems as though in the motion there may not be an agreement, and so I just wanted to clarify those things before I entered any order.
Judge, the concern that I had in speaking with Mr. Cox's firm, who still represents Ms. Gardner for purposes of the writ that is pending before the 5th DCA regarding the husband-wife privilege, there was a concern that was shared by me and the other attorneys handling that if we did not raise the issue, that we perhaps could be waiving it. And so with respect to the attorney-client issue, I believe there is an agreement based on what was discussed with the court previously. The motion was filed incorporating the entirety of Mr. Cox's prior motion in order to make it clear to this court, because it was a separate case number. I don't know if
there wasn't even a case number.
It wasn't even a case number, but a separate matter in our view, that we were not waiving the husband-wife privilege before this court.
Okay.
And so I believe the content blind review would be appropriate and agreed to based on the attorney-client issue, but we are preserving the husband-wife issue before this court under this case number.
All right, because I didn't handle that, how is the filter agent going to know what? So I'm assuming that based on Judge Carbula's previous ruling, she denied any objection, overruled it, allowed review of those messages. How is the filter agent going to know what to actually open up and review and what not to open up and review? That's my issue at this point.
With respect to the husband-wife?
So, yes. So, would it just be, and I don't want to oversimplify it, if that makes any sense, like, would it just be emails, messages, potentially photographs, things of that nature that would require an actual content review? And is there an ability for the attorneys to identify for the court how the agent would look through that? That is like a phone number, multiple phone numbers. Do you see what I'm saying?
Yes, Judge. So I think the first step is whether or not the judge is going to direct the state to remove all communications between Ms. Gardner and her husband, Mr. Fernandez, and if the state is going to order, or if the court is going to order the state to do that, I think there are two ways. One, it's either a content blind that the state has agreed to with respect to the attorney-client communication, or a more traditional taint review where an attorney has to, a neutral, and detached magistrate would be our position, would be best suited to review those communications between the two and determine whether or not those are in fact privileged under the husband-wife statutory privilege. I, of course, can provide the court and the state with the phone numbers utilized by Ms. Gardner and Mr. Fernandez, as well as their email addresses, for them to initially identify those communications that would have to be reviewed if the court was not going to do a content blind review. But I think the first step is whether or not the court is either going to disagree with Judge Carbula and find that those should be removed, or agree with Judge Carbula and find that those are not privileged. It's our position, obviously, that they are privileged and that Judge Carbula erred, which is why we have appealed to the 5th DCA. And obviously, if the 5th DCA agrees with us, then we have another disqualification issue with the state.
What is?
They're reviewing them or have reviewed them.
What's the status of the writ?
So there was a response and a reply filed. I believe the state had filed a reply saying that the issue was now moot and the writ should be dismissed. And Mr. Cox's firm replied to that, opposing that the writ be dismissed and arguing that it should be decided on the merits.
Mr. Fernandez is in the same position as what Mr. Crony just outlined, other than they filed a motion to dismiss. We filed the appeal, they filed a reply, a year went by, then the AG's office filed the motion to dismiss. We responded, and we're waiting on an order one way or the other.
When was the response?
About 45 days ago, maybe longer, somewhere in the neighborhood of 45 to 60 days, we filed our written response to their motion to dismiss, and we're waiting on an order either the merits or the motion.
Has this information already been disseminated among the parties that you all, let's just stick with the spousal privilege for this question, okay? Has it been disseminated or no?
Judge, it was on Next Point and was on the device extractions that were provided to us by the state.
But that has all been taken down.
So from our perspective, we still have it, right? I think the order was to the state to get rid of the device downloads and start anew.
Okay.
Has it been taken down?
I'm sorry. Next Point is not active anymore. It's disabled.
Okay, so it's been taken down.
We do have, obviously, all their cell phone downloads. Ms. Gardner's cell phone download that went through the taint process. The Google and iCloud and all those, I told the court we would delete them and wait for the returns.
And Judge, the response to the motion to dismiss was April 15th. So it's been there about 60 days at the 5th DCA.
Okay. And I'm focusing on the spousal privilege issue, okay? Do the parties believe that this objection is only contained on what has been put before the court, these 8 devices? And I also needed clarification on what property you believe for Mr. Fernandez as well. So his electronic devices is only contained on that? I'm asking because in looking at the state's discovery, their documents, I don't know the full. I don't know if they confiscated documents or other things that need review as well by a filter team.
I'm not sure I understand your question.
Okay, I need you to identify the property that you believe should be filtered by some sort of agent or neutral person before it's ultimately disclosed. Is it contained just in the electronic documents, electronic devices that have previously been discussed through motions, or do you believe that there's additional evidence that needs a filter review? That's my question.
I understand your question now. I'm specifically
to Mr. Fernandez. I think that
husband-wife privilege.
correct.
I would be glad to provide that answer. I don't know specifically right now, but I can provide that to you via memo this week. However, my position up until the court has brought this to my attention was that issue was resolved until, so I guess it may be different. I'm not speaking as a team here in terms of Mr. Fernandez. Judge Carbula ruled against our position as to the husband-wife. We filed an appeal. We're waiting for an answer. My thought process was that if the appellate court agreed, it was going to open up a massive can of worms in which I was going to then come in and say we got a huge problem again. If they agreed with the state, then I didn't see an issue. I thought the issue was somewhat resolved up until the appellate court. Having said that, I will get you a list of all the electronic devices that could contain husband-wife privileges, Google Drives, text messages, iPhones, wiretaps, iCloud.
I would, I would prefer by exhibit, meaning like if y'all have the property storage cards that you all provide those to the court, then, with I don't know how Jacksonville Beach, like with sequence numbers, with actual property, that those are identified in that way so that whatever agent can go specifically instead of just saying, y'all have always told me, which I, basically accept as a fact that this is voluminous discovery and I don't want any confusion. And so as much as I can nail down and be as specific as possible, I would like to do that. To me, the best way to do it is to just direct by property card, by item, then the Jacksonville Police Department, number one, knows what to avoid, not to tamper with it in any way. Like when I say tamper with it, I mean look into it any further before some type of filter procedure is conducted. Then that agent knows how to transfer it. They know what they're going to transfer back, and then it's of record, in not just in a general sense, because I don't know how many MacBooks there are, how many, you know what I mean? Do you see what I'm saying?
No, I do, and specificity, it will definitely be best practice, and we will do that. However, if I was reading the state's mind right now, I would be suggesting that they're probably thinking, we won that issue. Like, we don't have, they can tamper all they want with it because they're free to look into it under their theory of prosecution. I'm not saying, so Ms. Gardner raised it again, okay? Right. And then in trying to craft the ruling, the state, by agreement of parties, I don't necessarily, by agreement, they said that they were going to do a content blind review. Ms. Gardner, in order not to waive any appellate issue, has then raised the spousal privilege. I'm not saying I'm disagreeing or I haven't ruled in that sense. I may adopt, but in order to facilitate the filter, I needed to know how and what the filter agent should review, how that person should do it, so that I could maintain the order, but in order to not have any additional prejudice, I could have it just identified by the filter agent in a sense that then it could be brought before this court, because I don't even know. I don't know if Judge Carbula knew.
I will provide a little insight just from the state's position. Mr. Dreiser's correct. I mean, this from the state's side is kind of a moot point. We've read these communications between Mr. Fernandez, Saldana, and Ms. Gardner, at least investigators have, based in good faith and reliance on Judge Carbula's ruling. But if the court were to disagree, understanding it's an evidentiary principle, we were allowed to do it for investigation purposes. We may not be allowed to introduce any of that at trial, certainly under the evidence code, and we could litigate that. But if Your Honor does want to change Judge Karpel's ruling and ask us to filter out marital privilege communications as well, that is not from, I'm not agreeing to a content blind removal. Content blind, I'm in agreement for the attorney-client. Spousal privilege is abrogated by Florida Statute 39.204 when there are communications involving a charge of child abuse, as is charged here. Any communications they may have had about what we allege to be the specific plan to murder Jared Bridegan that night with his child in the car, causing her to be in physical and mental danger. We would argue to this court that those communications are not privileged by abrogation from this statute. So the filter agent would not be doing content blind review if the court were to grant Ms. Gardner's portion of that motion at this stage in the litigation. We'd have to have an attorney and a filter team in litigation on that.
Okay.
I'm still going to get you what you asked for, specifically from...
Right, we should be able to identify the devices.
I understand your position.
There are no property cards from Jacksonville Beach. I'll just let everybody know that. They don't do it like the Jacksonville Sheriff's Office. But
how do they catalog their evidence?
They do it within their reports. There's a property section attached to each supplemental report. So we should be able to do it with some specificity and let Your Honor know what property we're speaking of.
I would like for the parties to get together, identify however they catalog their evidence, and identify which items on that evidence so I can attach it to the order with the exhibits. If there's anything additional, and while the issue may be settled, I'm not saying that it is or isn't. I mean, I just want to basically articulate in the order how the filter agent is to identify and catalog the information, and if it will be in a sense that, just like in the Sullivan case, essentially in, for lack of a better term, like buckets of, like, this is agreed on, it never is disclosed. This is not agreed on, meaning that there could be litigation on it. It's not that filter agents purview to make a legal ruling, so just identifying. So it would be, this agent, in my mind, would identify litigation material for both sides, and then the ones that are not. And so then they would just automatically be disclosed through normal discovery. So I'm not saying I will listen. I'm not going to pre-rule or prejudge. I'm going to have them identify. And so, and now, because Ms. Gardner has raised it again before this court, and this was pre-indictment, pre-arrest, and so maybe positions have changed and it needs to be litigated further. I don't know if it does. I may maintain the ruling, but it'll be the content blind as previously agreed. So I'm assuming everyone's all in agreement in that review.
Yes, Your Honor.
Yes, Your Honor. For the
Okay.
I previously had filed and given to the court and the state a list of all the counsel.
I just want to make sure on the record everyone is agreeing to content blind review for attorney-client privilege.
Yes, Your Honor.
Okay. All right. And so for the spousal privilege, the state, y'all are not in agreement.
Correct.
Right. We're not in agreement on what bucket it's in. We're not in agreement on how it should be done. We just have a total philosophical.
Or if it should be done. Right.
At all. Right. And then I guess now would be a good time for me to say on the record, so it's very clear for appellate review, on behalf of Mr. Fernandez, we either adopt Ms. Gardner's motion for the protective order as to spousal privilege, and we do not waive, and we never thought that we waived anything by filing the appeal. So I'm not necessarily calling it up. I will answer the court's questions, but we do still maintain our position as to the spousal privilege.
Okay, so what I intend to do is just have it identified, and then once it's identified, then if you all feel as though there's additional objections or if there's something else you'd like to bring to the court's attention, that's how I will proceed. But I essentially hit a roadblock, and I want to not put out multiple orders related to this. As much as I possibly can, I want to be comprehensive in one order, how it shall be done, what should be done, and then because of what was raised in Ms. Gardner's, I kind of hit a roadblock, and I wanted to ask those questions before I enter an order.
And
Understood.
so, Judge, are you asking for the contact information, phone numbers, email addresses, things of that nature that would have been used by Ms. Gardner and Mr. Fernandez at this time?
Yes.
Understood.
So that filter agent can then identify whatever files or content on these electronic devices that need to go for potential further litigation. Identify it for the defense, identify it for the state, and then we can basically deal with those issues as they come. Okay, so that's what I would like for you to do, and I would also I would like for the parties not to be narrow in thinking about the evidence. Just like in the Sullivan case when there were photographs taken of like storyboards by the defense and things like that. I need you all to think wider. Because I don't want inadvertent disclosure of potentially privileged information. Are there documents? Are there tangible exhibits that need filter review? If that is the case, I need to know. Okay, so I can be as comprehensive as I possibly can. Does that make sense? Yeah. And I need you to identify it for me so that I can identify it for the filter team. I will ask that person just to identify it for the parties, and then we can litigate as we see fit. Okay?
Yes, Your Honor.
Understood.
Okay. So that will be forthcoming. Y'all can send it to me, all the sides copied, and then I'll review it. And if I have questions, I may have to reach out. We can have a meeting about it. I don't think we need to do it in this sense. I have more of a general idea of where you all are in agreement and where you're not. Okay?
Yes, Your Honor.
Okay. Okay, and then there was another motion filed, a defense motion by Ms. Gardner. Ms. Peoples, you filed it on behalf of Ms. It was a defense motion to release defendant on bond to prohibit the state from using certain evidence at trial based on the failure to disclose favorable evidence, and also requesting other relief. Are you going to handle that? Mr. Crody?
For today, I can. We would like to set it for an evidentiary hearing in the future. We intend to call SL and KJ, the two individuals mentioned in that motion.
Am I reading this? Are you asking kind of for a Richardson hearing? Or because you're essentially, I know it's in a Brady bucket. However, you're also alleging failure to disclose, which Richardson does apply pre-trial. So I'm just asking for clarification on that.
In general, yes, but I think it's more. I think it's more because we've already had a critical hearing. And so that being the Arthur hearing. And so we're asking, I think that is a little bit different than Richardson because we've already completed a critical hearing in this case, and we're looking for sanctions against the state for their failure to disclose prior to that critical hearing. And that's the relief we're asking for. But I do agree that it is, it could be characterized as a Richardson hearing.
Okay. When do you all want to set it?
Judge, I had recommended to the state the week of 7/15. I understand they have some conflicts. I don't know what their position is.
I saw Mr. Baez filed a notice of unavailability as well. I can't remember I can pull it up, but. What, there was some time this week too, correct?
Yeah.
Okay. All right. How long do you think it will take?
Half a day, Judge.
You have conflicts the week of July 15th.
Well, Your Honor, I would want to put on the record, I know the court may be inclined to grant a hearing anyway, but the state feels the court could deny this without the need for a hearing based on the review of the affidavits and the motion. So that's our first request, is that the court just deny this.
Okay.
But if the court is going to have a hearing, I think we're available the week of the 22nd.
Just down that week. I mean,
Why, so the Richardson case plus any cases that interpret that decision, why would this be different than they could just say in open court, there's a discovery violation? Then it's incumbent upon the court / error if I don't conduct some sort of inquiry into the alleged discovery violation.
They didn't allege it. They didn't allege Richardson. The court did.
Well,
So, I mean, I'll say that.
I'm not saying I'm not alleging anything. I don't know anything about it. What I'm saying is the cases that interpret Richardson, there isn't any magic language that says Richardson hearing. It is an allegation of a discovery violation that then makes it mandatory in the court to inquire. Not necessarily that we have a whole nother. What hearing are you saying I should be able to deny without any inquiry?
The defense is alleged in their motion and attached affidavits does not constitute any discovery violation nor any Brady violation on its face. It's insufficient. And I think the court can summarily deny it.
Okay. So you're saying no hearing into whether there's a discovery violation?
Yeah, on its face of their allegations, there is not a discovery violation nor a Brady violation. That's the state's position.
And Judge, we disagree with that. I don't know if the court wants to litigate it right now, but there were clear omissions by the state of favorable evidence that was not provided to the defense, and we can establish that by calling witnesses very easily. And these include contemporaneous statements during these meetings that the state had with material witnesses that were not recorded, that were not reported on, that the material witness is prepared to come into court and say things that contradict exactly how the state portrayed them during their Arthur hearing. And that is the definition of favorable evidence.
All right. Before I schedule anything, I want to make sure I know what I'm scheduling, and so that the parties can be adequately prepared. So the state is objecting to any inquiry in the court related to any discovery violation.
Correct. We are in the middle of discovery. We have just begun the deposition process. This is.
I mean, I can find the case that says it. I would agree with you, Mr. Mizrahi, that generally speaking, Richardson, that case applies, and it generally is applies in situations where you're in the middle of the trial, or you're about to start the trial. There is another case, and I can't remember what DCA. If you give me a moment, I can find it and I can provide it. That says it also applies during the course of pretrial proceedings. So let me take a recess. I'm going to find that case so that we're all kind of on the same page.
Judge, if I could briefly In our motion, we cited Rule 3.220B4, which says, as soon as practicable after filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant as to any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations. As soon as practical. It's not during the course of discovery that the defense can find this out. It's as soon as they know it, after they have filed a charging document, they have to turn it over.
Okay, I hear you. Let me take a recess, okay? One is Landry v. State, 931 Southern 2nd, 1063. I give that to you. I'll read a pertinent part of it, which it says, a Richardson hearing is required when there is a possible discovery violation in order to flesh out whether there has indeed been a discovery violation. So I essentially interpret that. I mean, there are other cases too. I mean, the standard is very low, and it doesn't have to be an actual, it has to be a possible, so I cite that one. Then there's Scipio v. State. It's a Florida Supreme Court case, 928 Southern 2nd, 1138, which actually involves a decision by the 5th and the 4th, going to page 15, starting there. It goes through the obligations. It interprets both the civil rules, which there are more civil disputes about discovery. It generally doesn't happen as much in criminal cases, but it goes on through that. And I would just encourage you all to look that case over. It refers to discovery violations in criminal cases and what the court's obligations are. And then State v. Randall, which is 947 Southern 2nd, 609. It's a 2007 case out of the 3rd District, which it was pre-trial. It was a very old case. The trial court in that case was frustrated with the parties, conducted one Richardson hearing, set a discovery deadline. There were allegations of other discovery violations. The court failed, basically failed to do a Richardson hearing, and it was ultimately reversed for those reasons. So if you all, I'm giving this to you in light of the issues that have been brought by motion to the court, not requesting a Richardson hearing, but I don't think those words are required. If you want to look this over, if the state wants to maintain an objection to any inquiry, I will hear you out. But I'm going to do that sooner rather than later, not wait to July, whatever date y'all were talking about.
My suggestion, Your Honor, we received this motion after a press conference on Friday, so we haven't had a long time to digest all of this stuff. We will respond to the defense motion in writing.
Okay.
Attached responses where the state believes that we have disclosed everything the defense claims, and respond to it in the interim, and then the court can review that.
Okay.
In the interim, we can schedule a hearing.
Just on whether there should be an inquiry or not.
No, once the court hears our response, the court can then make a decision about whether or not there should be an inquiry or not. Once the court sees our response, I don't think we need a separate hearing. We will rely upon our written motion.
Okay.
And obviously, if the defense wants to respond to that written motion, they can obviously have time to do that.
How long do you all need to do that?
The written motion can be done probably within a week to 10 days for sure, if not sooner. So that before the holiday, for sure. And then we would ask for maybe the hearing and then obviously the defense can respond in the hearing. The parties, I know the court is down the 22nd, maybe the week of the 29th.
What's the defense position on that?
We would love a written reply so we can be prepared for the hearing.
I will point out, I believe someone, I don't know who it was, referenced affidavits. It's not on the docket. How did y'all?
Judge, we did not file those because we turned them over as a matter of discovery obligation, timely turned them over to the state because those are witnesses we have listed. And under the rules, we have to disclose any statements we have that are signed by witnesses that we've listed. So that's why we turned them over. It's our intent to call live witnesses.
So you don't want me to, I don't need to see those.
We're not asking you to consider those. If the state wants to provide those,
We'll probably attach them to our written
that's up to
response,
them.
Judge.
Okay. What do you think about the date?
I know that I am unavailable the week of the 29th. I'll be out of the United States on military orders, so I'll defer to Mr. Baez on the scheduling.
Okay. Mr. Baez?
Yes. Looking at my schedule, the week
No, they're saying the 29th of July.
And Judge, Miss Peoples just indicated to me that she's in trial that week also, so I just wanted to put that on the record. So I don't know what Mr. Baez's position is then for the week of the 29th.
So we couldn't do it the 15th, the week of the 15th? The state had a...
I'm in a first-degree murder trial in front of Judge Salem, and
I'm in a first-degree murder trial in front of Judge Sachs.
Okay.
there's always a chance.
What about the 8th? What about the 8th? Who's out then?
That just doesn't give us a lot of time. It doesn't give us a lot of time to do what we need to do, albeit it certainly interferes with our ability to prepare for our 2 first-degree murders that are set the week of the 15th.
And just so Mr. Baez knows, I'm also out that week.
You'll be by yourself. When do you come back?
I fly back the August 8th. So
How about August 9th, 9 a.m.?
Judge, I'm going to be cut.
You're out of the country.
And I'll still be on Middle Eastern time. So
Okay.
The week of the
We need to do it sooner rather than later. I mean, this is... When are you unavailable, Mr. Baez?
My voice will be week of the first so I
And we can let the court know we are conducting depositions during this period. So I understand the court wants to resolve it, as does the state. But if we did it later, we're still accomplishing things, as opposed to what we were doing before, which we weren't accomplishing a lot.
Judge, we had 2 days of depositions last week, and we have depositions all day July 19th in this case.
All right, so what I'm hearing from y'all is that everyone is not essentially available until the week of August 12th. That's what I'm hearing.
The state's available the 12th, Your Honor.
I'm available. Ms. Peoples is available, and I'll defer to Mr. Baez.
And what I'm proposing is a relatively short hearing related to whether there is a discovery violation or not. That's what I'm proposing, not some long, drawn-out hearing. I don't know.
They said they were going to call the two witnesses live. That's why we were assuming it would be a longer hearing.
I mean, Judge, the issue here is whether or not at least one of the witnesses made material, favorable statements to these two prosecutors, and whether or not they did not disclose those to us.
So you're going to call in.
Our intent is to call the witness and have her under oath tell the judge exactly what she told these two prosecutors.
Okay.
Unless the state wants to concede that the witness did in fact make favorable statements to them and they didn't disclose them.
The state will concede that we submitted a transcript which contained those statements to defense counsel, which they had for well before the hearings.
Two different things, Judge. They're talking about the grand jury. We're not contesting that. There was a second meeting that was not recorded, and there was no police report, and that's what's at issue.
All right. What about August 16th?
Great.
Yes, Your Honor.
Okay. August 16th, 9 a.m., courtroom 406, and it'll be hearing on motion if necessary. Okay. Otherwise, I'll just be checking in on the discovery.
Are you back to 9 o'clock then, or is it still 9:30?
9 o'clock.
Yes, Judge.
You want Mr. Fernandez here as like a free trial that day?
Yes. Same date, same time for Mr. Fernandez. And if the attorneys need me to repeat those sites, I can. All right. Court's in recess to transfer back to 308.